Okay, so if you're gearing up for the bar in Australia, you know there are certain cases that are more than just history. They're basically the rule book. We're going to dive into one of the big ones today, Makita versus Sprowles. Now, on the surface, it looks like a simple slip and fall, but trust me, this case literally wrote the modern playbook for how expert witnesses give evidence in court. If you can get your head around this, you're a huge step closer to mastering a critical skill for any trial lawyer.
The whole thing really comes down to one very tricky question. How on earth do you prove that something, let's say a simple set of stairs, is fundamentally dangerous?
And then, here's the kicker. How do you possibly make that argument stick when all the real-world evidence, years and years of people just walking up and down those exact same stairs, suggests the complete opposite? That was the puzzle the court had to solve.
All right, let's set the scene. This isn't just some dry legal theory. It's a real story about a real accident that clawed its way all the way up to the NSW Court of Appeal, and in doing so, changed everything.
So it all kicks off way back in 1986. Vicky Sprowles, who works at Makita, takes a tumble on a concrete staircase there. It takes forever, but in the year 2000, a judge finds Makita was negligent and awards her this huge payout. Naturally, Makita, staring down the barrel of that bill, appeals it. And that appeal? That's where this case becomes a legend.
And when I say huge, I'm not kidding. We're talking over $1.1 million. Now, what's so fascinating here is that this massive award, this whole initial decision, was basically balancing on the evidence of just one single expert witness.
And that brings us right to the heart of the fight. At the trial, Ms. Sprowles' case was built almost entirely on the scientific opinion of an expert. But that opinion was about to go head-to-head with some pretty powerful, good old-fashioned common sense. So this expert was Associate Professor Morton, a physicist who knew his stuff when it came to slipping accidents. No question, he was highly qualified. And at that first trial, his testimony was absolutely killer. The judge was completely sold on his scientific analysis.
So Professor Morton runs his tests, and he comes to these really clear conclusions. He says, look, the stairs are smooth. And for the kind of shoes Ms. Sprowles was wearing, they were straight up dangerous. In his expert opinion, the dangerously slippery condition was the direct cause of her fall. Case closed, right? Well, not so fast.
This is exactly where the Court of Appeals zoomed in. So on one side, you've got the expert in his lab with his tests, but on the other side, you have the undeniable facts of everyday life. Miss Sprowles herself had gone up and down those stairs at least 500 times and never fallen. Her boss, who wore leather-soled shoes, which, are even more slippery, said he never had a problem. And maybe the biggest thing, there was absolutely no evidence that anyone else had ever slipped on those stairs.
And this is where things really started to fall apart for the expert. When the court took a closer look at Professor Morton's own data, they found a huge inconsistency. According to his own tests, using the safety standards he put forward, the sole of Ms. Sprowles' shoe was unsafe. It had a friction coefficient of 0.34. But, and this is a big but, the heel of the exact same shoe, it tested as safe, with a coefficient of 0.53. The expert never really explained that contradiction. He couldn't say why the unsafe sole would cause a slip when the safe heel, which he claimed hits the ground first, didn't prevent it.
So, the Court of Appeal overturns the decision. And in his judgment, Justice Heydon does something incredible. He doesn't just decide the case, he lays out this crystal-clear blueprint for what every expert witness needs to do from now on. And this is the part that every aspiring barrister needs to tattoo on their brain.
Justice Heydon dropped this brilliant Latin phrase, ipse dictit. It basically means he himself said it, and his point was so powerful. A court is not just going to accept a conclusion because some super qualified expert says so. An expert's opinion has got to be more than just their word.
So just to be clear, ipse dixit is any statement that's just propped up by the authority of the person saying it, with no actual proof. The court basically said that expert evidence can't just be some magical announcement from on high. It has to be something the judge can actually follow, test, and verify for themselves.
And that logic leads us straight to what we all now call the Makita rules, this essential four-part checklist. Okay, step 1. The expert's got to lay out all the facts and assumptions their opinion is based on. No hiding the ball. 2. They have to explain their process, their methodology. 3, and this is the big one, they have to show their work, the actual reasoning that connects the facts to their conclusion. And finally, number 4, they have to give the court the tools, the criteria, to judge that opinion for itself.
So, what's the takeaway for you? The future barrister. Well, this isn't just a boring set of rules for your expert to tick off. No, this is a weapon. It's a powerful tool for your own advocacy.
Look, when you're prepping for a trial or you're in the middle of your bar exams, think of this checklist as your secret weapon for cross-examination. Has the other side's expert actually stated their assumptions? Have they shown their reasoning? Have they given the court a way to check their work? If the answer is no to any of those, you know exactly where to attack.
Think of this as your field guide for spotting bad evidence. A weak report, one that fails the Makita test, just gives you a conclusion, an ipse dixit. It doesn't tell you the why or the how, but a strong report, it does the exact opposite. It shows its reasoning, it's upfront about its assumptions, and it basically empowers the judge to reach that same conclusion all on their own. And that, right there, is the difference between evidence that wins a case and evidence that gets torn to shreds.
So if you remember one thing, let it be this. The ultimate legacy of Makita versus Sprowles is that an expert's job is not to be some oracle who just hands down the answer. Their job is to be a teacher. It's to give the court the knowledge and the framework to understand the evidence and then come to its own independent conclusion.
These principles are not just academic. They're fundamental tools you're going to use your entire career. So, looking back at all the facts, the expert's report, the real-world evidence of those stairs, I want you to ask yourself, now that you're armed with the Makita rulebook, could you have run that appeal and won?